Hello and good afternoon. Thanks for joining us today for our second of 4 webinars on decisional capacity. Today's focus is on the corporate lawyer's retainer. For all lawyers, a client's capacity, their vulnerability, their susceptibility to undue influence it should be top of mind. It's a big concern. It's not just for the estates and trust lawyers like Ian and myself, or even elder law practitioners. We are all faced with these challenges given our aging demographic. Lawyers in any practice area are obligated to ensure in any retainer that they have that their clients have the requisite capacity to retain, to give instructions, to execute documents that go along with that retainer. And so this webinar is just a general overview, firstly, of decisional capacity, and then related issues as they affect a corporate lawyer. So what should a corporate lawyer know or do when there are concerns about a client's capacity, and the client, for example, is, let's say, a director of a corporation or a majority shareholder, or is executing a contract or entering into a transaction? What role can or should power of attorney documents and the attorney themselves play in the corporate context? Our goal is to assist in the understanding of the lawyer's obligation and the rules upon which a lawyer's conduct will be scrutinized, how to reconcile both the legislative and common law precedent, and the legal limitations on guardians and attorneys. So in providing the overview of decisional capacity and the lawyer's role, we know that it's more important than ever. And why? Contextually, because our clientele, our population, is aging rapidly. Globally, we're facing the largest demographic shift in the history of mankind, or humankind, let's say. Not just mankind, right?
I agree.
Yeah?
Totally. Humankind.
In 2017, there was an estimated 962 million people aged 60 or over in the world. And that rate of growth is 3% per year. And persons aged 80 or over globally, it is projected to triple by 2050 from 137 million last year to 425 million. It's predicted by 2036 there will be 11 million seniors in Canada. 15% of our population is already over the age of 65. For men in Canada, life expectancy is now at an all-time high at age 86, and for women, 89. While it's certainly not the case at all, older adults have mental capacity challenges. With longevity comes the opportunity for medical issues affecting cognition. We also have other related issues or diseases or disorders that affect capacity and increase in individuals' vulnerability. In 2010, an estimated 36 million people worldwide were living with dementia, and that number is expected to double within 20 years. Dementia is a general term. It's used to describe a range of symptoms associated with a decline in mental ability, severe enough to affect a person's daily life. It's caused by a variety of diseases, the most prevalent of which is Alzheimer's disease. According to the Alzheimer's Society worldwide, there is a newly reported case every 69 seconds. In the US, Alzheimer's is the 6th leading cause of death with no cure. 1 in 11 Canadians over the age of 65 currently has Alzheimer's or a related dementia. In Canada, dementia affects 20% of seniors by the age of 80 and 40% by the age of 90. And so normal aging, untreated or diagnosed schizophrenia, depression, bipolar disorder, psychotic disorders, delusions, debilitating illnesses, senility, drug and alcohol abuse, addiction, can all affect capacity. And so now Ian's going to talk a bit about why capacity issues are so complex and the legal criteria.
You know, I'm always struck by Dr. Ken Shulman up at Sunnybrook, who's a leading expert medical practitioner in this area. He describes the reality of capacity with an aging population. The problem is that our bodies are outgrowing our minds, and they're outlasting our minds, I mean. And so if you're physically living longer, but your brain is not surviving, so to speak, in the same level, we're going to be faced with complex and what are sort of personal determinations on capacity. So the law is pretty clear that you've got to look at the facts and the circumstances and mix that in with what are some of the sort of basic parameters of the testing. Capacity, for example, to do a will is to know and understand the nature and effect of your dispositions and those who would properly enjoy your bounty. That sort of rings off off the page pretty easily, and what does that mean? So you have to look at the situation and determine it. So there's no real pure definition for capacity in every scenario, and I'm going to talk a little bit about today. Kim and I are going to talk a little bit about where the different, I would say, the parameters you have to consider when talking about capacity. Starting off, though, the nice thing is we have a presumption of capacity. And capacity in and of itself is both legislatively and in the common law something that is preserved by the fact that you are presumed to have capacity. But it's a decision-specific, task-oriented determination. So if we look at the circumstances of the determination as to whether or not someone has capacity, we have to look at the circumstances surrounding that person and how difficult is the determination. For example, if someone comes to see you and says, I want to change my will, but all I want to do is change the executor, that task is modest in the grand scheme of things in terms of what is going to happen to your overall estate in every respect. And so that decision is determined, what are the circumstances around that person's life? Is it something that is, are they in a high stress situation? Well, the choice of executor may or may not be that difficult to come to. And so your level of cognition can be informed by the nature of the decision you need to make. The different analysis is required under granting powers of attorney. So a continuing power of attorney, or CPOAP, versus a power of attorney for personal care, those short forms. There are different tests in regard to that. It used to be the old Calvert decision, which still prevails. Justice Mary Lou Donato, who did the decision as she then was, sort of set out this food chain. And they said, look, the capacity to do a will may be a bit higher, capacity to do a power of attorney for property may be down a bit lower, power of attorney for personal care may be a bit lower, and questions of capacity, I've always said to Mary, are at the very lowest, and that demonstrates my reality in terms of where I sort of benchmark these considerations, but it's not a test as the slide says. So, as I say, we've got to look at capacity being fluctuating, and Dr. Herman at Sunnybrook, Nathan Herman has, and with Ken Schulman and Carol Cohen and others have written on the determination of whether can you have good days and bad days. And I think generally speaking with our clients, we have to be realistic that once you have lost capacity, and it's a determination that we'll come to and how we come to that lost capacity, the data is pretty strong, you never come back. But you can certainly have good days and bad days in the framework of someone who has capacity. But certainly the medical data is that if you don't have capacity, it's very difficult to come back from it. And so those are sorts of things that we can look at, and again, try to come to some determination as to how to assess them. A capacity assessment is done by an expert, and the examination itself is done by a pro, so to speak. It's sort of like when I get into cases and I've got a tax problem, I'll say, look, I don't know anything about tax. We're going to get a tax expertise here. Well, and the same thing with capacity. If I'm in a situation where I've got to consider getting a capacity assessment, I want to get a doctor who, well, not necessarily a doctor, capacity assessor, and we'll talk about how you qualify to do these assessments shortly, but we want to get an expert in to determine capacity from a medical perspective. Ultimately, it lands on our hands and our shoulders to make the determination as lawyers, but that data from a medical practitioner is vital. Our next slide, the capacity situation specific, of course, but generally speaking, the test, a component of any test of capacity is the ability to understand and process information. And so can you apply the relevant information to the circumstances and weigh the foreseeable risks and benefits of the decision? And that comes back to my comment that For example, a test that has been tried and true in the context of a capacity assessment for a will is this idea that do you know and understand the nature and effect of your dispositions and those who would properly take your bounty. That is, I call it a test. Probably I'd fail my test for calling it because I've just said it's not a test, but it is those are parameters upon which the courts have used, that's legal terminology the courts have used to support the analysis. So the question of capacity, as I say, is a legal and medical factors that need to be considered, and it is not a perfect science. It's, as identified, it looks at different components. So it's important to note that the nature of the legislation that governs capacity assessments, we really have got to look at things like the Substitute Decisions Act and also look at the common law. What are the courts doing? Ultimately, it is a incredibly serious thing to determine someone is incapable. It is, as the Justice Quinn in the old Koch decision, when I say old, it was in the 90s, I guess almost, that he described it, when you make a determination of a finding of incapacity, it is almost quasi-criminal in a sense. You have taken away their liberty in some level, so you have to be very, very careful. Now, that may be overstating it, but it's been argued that it doesn't go that high, but the point is, it's realistically, that's truth. I mean, if you have someone found incapable, you're going to be taking away their liberties. The legislation, as I say, are key. We're looking at the relevant statutes. We're looking at the Substitute Decisions Act, which provides the statutory criteria to determine capacity in the context of granting powers of attorney for property and powers of attorney for personal care, and in the context of appointing statutory guardians, which is a whole determination in and of itself. The Mental Health Act, there's not that many acts, quite frankly, which is nice. If I want to look to legislation, I can go to the Substitute Decisions Act in the context of powers of attorney, the Mental Health Act, which deals with voluntary and informal admissions to designated psychiatric facilities, the Healthcare Consent Act, which drives decision-making in terms of patients finding incapacities in the context of long-term care facilities and the like, and then finally the Consent and Capacity Board, which is a tribunal that will hear matters that are determinations where a determination of incapacity has been found in the right circumstances. The Consent and Capacity Board is a tribunal that you can consider going to appeal a finding of incapacity under the Healthcare Consent Act, under the Mental Health Act, under the Substitute Decisions. So there's a tribunal available to set aside a finding of incapacity, essentially. And most of these, the Consent and Capacity Board hearings relate mostly to matters relating to Mental Health Act, voluntary and involuntary placements into a psychiatric facility, but it's an avenue of, I guess we'd call it, appeal. So those are sort of an overview of the kinds of areas. It's not that complex in terms of the nature of the legislation, but understanding the legislation and the nuances within each of those categories can get a little bit spicy. So why don't we stop there and turn to your area of capacity in the corporate context. Kim?
Sure. Yeah, I'm going to start with looking at the capacity to instruct counsel. So perhaps you have a long-term client who one day asks you to assist in doing something that just isn't usual for them, out of the ordinary, let's say. And the client is exhibiting signs of confusion, perhaps, doesn't fully absorb what your advice is, and has maybe some obvious memory issues. So I think at that point, you might be asking yourself, or you ought to be asking yourself, is your client capable of instructing you? And how do you fulfill your role? We know, because Ian told us a minute ago, that there's a rebuttable presumption that an adult client is capable of instructing counsel. But it's important to note that the requisite capacity to instruct counsel involves the ability to understand the associated financial and legal issues. So it really, I mean, you want to look at what obviously the matter at hand is, but you need to make sure that your client understands the financial consequences involved. A lawyer will have to make a delicate but complicated determination. In order to have capacity to instruct counsel, primarily your client should be able to understand the context of the decision. In other words, what they've asked the lawyer to do and why. Know the specific choices that they have, be able to understand the process and to process the information, to understand the advice and the options that the lawyer presents, and to appreciate the consequences of the choices. In other words, the pros, the cons, the risks. The client should have the ability to understand the retainer agreement will confer contractual liability on them, and should have the ability to retain information on an ongoing basis so as to be able to meaningfully interact with the lawyer. It's not necessary that the client understand all of the details pursuant to their case or to pursue it. Just as any person can hire an expert to handle complex affairs that are beyond their own expertise, a client can rely on their lawyer to represent them and to help or facilitate understanding the specific details and the process involved. So a capacity analysis may be different for giving instructions about a complex corporate transaction than, for example, assisting a client in making a treatment decision under the Healthcare Consent Act. So Ian, what about capacity to contract? Because that's a big one in terms of corporate transactions.
Yeah, it's a great question, and it's one that, we've got some general concepts and parameters, as I said, that set the stage on how we're going to deal with our clients when we have capacity issues. But this is a great starting point to roll our sleeves up and look at a practical illustration of a capacity question. And the capacity to contract is, as the slide identifies, of course, Section 2 says of the Substantive Decisions Act presumes if you're over 18, you're presumed to be capable of entering into a contract. That's a nice starting point, but so what? I guess really the person is entitled to that presumption, but outside of that, there really is no statutory criteria determining capacity to contract. So when we look at this test, it's what Kim's already said, looking at the nature of the contract, understanding the effect of it and its circumstances, those kinds of things. Well, these are all similar themes that tie into what I've described as the old Banks and Goodfellow definition of capacity to do a will. It's the same parameters, it's just nuances on them. And so, to understand the nature and effect of your dispositions and those who would enjoy your bounty. Well, look where we're getting at here. Knowing that, there's some good law on this that gives you a little bit of exposure to some of the courts have sort of played with it. There's a case called Bank of Nova Scotia and Kelly, which is a 1973 decision, but it specifically addresses the question of the capacity to enter into a contract, including real estate transactions. It's the ability to understand it, and it's the ability to understand the specific effect in the circumstances. And I think that's really the key is that Kim's right. It's so right about the fact that, the courts don't expect you to have a deep understanding. Very wealthy, complex estate planning matters. Many of the clients don't really understand, and not even wealthy. I mean, I've got clients who leave the room after doing the will, and they don't really understand exactly what's gone on. They just know generally what's going on, and they don't get into the minutia. And it's the same here with the ability to contract. I think the key is the emphasis is that what are the ramifications of entering into the contract? And that's what, that theme goes through every test of capacity, but the courts have emphasized it in the context of contracts. So that gives you sort of a starting point, and as I say, I don't know that the language of the case law or the act really get us much further along except to give us our intuitive testing. And so if you have the kind of parameters, do you understand the contract, you know its effect, understand its effect, then you ask questions around that. And we'll talk about the type of documentation that's required. Another area to consider is capacity to grant and revoke powers of attorney, and this is tied to the Substantive Decisions Act in Ontario, of course, gives us a specific guidelines. And one of the great things about the Substantive Decisions Act is it actually codifies or at least crystallizes the tests that are expected in some of these scenarios, which is really in 1994 when it came out and then amended in 96, it was pretty revolutionary and in terms of the legislation that was out there now. Ontario, of course, is now way behind on this because we haven't refreshed our legislation. But
we had lots of good Law Commission for Ontario recommendations.
That's right, and lots of work has been done, but the governments have had other priorities and haven't really addressed these things. But even this is a good, again, we're looking at the kinds of things. These later, we'll talk about some of the specific questions you may want to consider, but I go to these sections and we'll talk about some of the other tests that are in the Act, and I use these as my guideposts for questions. And if I've got someone who comes in and says they want to grant or revoke a power of attorney, I've got these Section 8 kind of parameters, and then I ask questions around it. And I find it really helpful. In fact, in my own power of attorney, I put some of these points right in the power of attorney, and I say we've canvassed this, and when I go through the power of attorney, I actually canvass that you know that he or she may be, if capable, revoke the continuing power of attorney. Well, that's something I'll actually put in my power of attorney and say, you actually know you can get out of this. And I'll ask that question to them, and I'll put it right in the document that he or she's considered that. So that's the sort of parameters that Section 1 and 8 provides, and you can read the Act and the slides that demonstrate the kinds of questions you want. But the next is, of course, capacity to manage property. And as I say, my own personal view, and for whatever it's worth, is I do think there's a certain amount of food chain of capacity that goes on here because it's tied to the decision making that's required. And as Kim has said, it's task specific. Well, task specific means what kind of task are you undertaking? Well, continuing power of attorney for personal care is different than a continuing power of attorney for property. So the capacity to manage property is a more fulsome consideration as to their ability because of the consequences. So capacity to manage property, Section 6 of the SDA sends out a pretty clear message. Looking at the ability to understand the information, the ability to appreciate the foreseeable consequences. You're starting to see some themes here with the legislation, and no legislation is, as detailed as you'd want, but sometimes. But this sure gives you some good parameters. There are two circumstances only which a person can be deemed incapable in Ontario to manage property, and that is under the Mental Health Act, and that requires a physician to assess the person's capacity, and then the other is under the Substitute Decisions Act, where someone has been determined to be incapable, and the capacity assessor has made the determination that there is incapacity. So you now have at least the general legislation to go to. You have the specific tests that are outlined in the legislation. So you're armed pretty well with an illustration of the capacity to contract. You're armed pretty well to start to really dive into the corporate considerations. And so, Kim, let's talk about capacity to act as a director, incorporating companies and all of that sort of stuff. Where does that fall into the whole sphere of what we need to consider and what we need to determine in terms of the necessary questions to ask and make sure that our client has sufficient capacity? So
capacity plays obviously a significant role in who can and cannot act as a director and who can and cannot incorporate a corporation. So until just recently, Section 105, Sub 1 of the Canadian Business Corporations Act stated the disqualification of anyone who is of unsound mind and has been so found by a court in Canada or indeed in another jurisdiction. This provision is obviously extremely outdated and unhelpful. The terminology unsound mind was not even defined, and no one, quite frankly, knew what it meant. With the Act to amend the CBCA and also some other legislation also relevant at the time, the Canada Cooperatives Act, the Canada Not-for-Profit Corporations Act, and the Competition Act, and those legislative amendments were passed May 1st, 2018. Section 105 now states disqualification from being a director of a corporation is anyone who is incapable. And also Section 126 Sub 1 of the Canada Not-for-Profit Corporations Act, applicable to corporations with share capital, disqualification includes anyone who has been declared incapable by a court in Canada or elsewhere from being a director of a not-for-profit corporation. And thankfully, incapable is now a defined term, and that's very helpful. In both the CBCA and Canada Not-for-Profit Corporations Act, the definition is of incapable means that the individual is found under the laws of a province to be unable, other than by reason of minority, to manage their property, or is declared to be incapable by any court in a jurisdiction outside of Canada. So the amending legislation also added to both the CBCA and the NFP Act, an individual may incorporate a corporation only if the individual is not incapable. So therefore, any individual who's found incapable of managing their property in Canada, and that test, again, if we can call it a test, was set out in the Substitute Decisions Act, cannot act as a director of a corporation nor incorporate a corporation. So since a person, though, cannot be globally incapable or capable, this may cause uncertainty where the legislation is not correlative to the specific decision. So there may be a hurdle with respect to that at some point, but
yeah, it's interesting, isn't it? Because it's, there's a clear message in the legislation in terms of incapacity knocks you out of the box, corporately or in a charitable situation, but or not for profit, I mean. But what do you do if you're able to continue on? You're still instructing. You've got capacity to instruct counsel, but you're found incapable, which is not an impossible scenario. And then you're looking at that and you're saying, well, what do I do? If I was a director, should I be taking the active steps as being someone who's incapable, or do I just step back as acting for the alleged incapable? Because you're still kind of half in the game, yeah. And the legislation doesn't help us at all in that regard.
So there's one example. It's a reported decision, but it's from Quebec, and it's in the corporate director context. And this is a case of Grinwald and Grinwald. It's a 2002 case. Mr. Grinwald had given his former wife and daughter shares of a corporation that he founded. And so he made his wife and daughter directors, but he maintained the controlling interest in the corporation. He made the decisions, he managed the company on his own. Years later, he had some surgery, and following that, his doctors concluded that he was mentally impaired and that he couldn't manage his financial affairs, nor could he make even basic decisions regarding his physical well-being. So Mr. Grinwald's new common law wife was approved by a court to be his mandatory under a mandate, and that's basically the same idea as our power of attorney legislation in Ontario, but in Quebec they call it a mandate. So oppression remedy proceedings were commenced by the common law spouse against the former wife and daughter who had acquired voting shares in the corporation through preferred share subscriptions, and the common law spouse sought to have those canceled. And the court said that she did have the standing to bring the oppression claim, but that her status as a mandatory didn't entitle her as a right to take his place as the director. Right. And so she has to qualify herself and be duly elected to that position. And the court at the same time did confirm that Mr. Grinwald was incapable of acting as a director pursuant to Section 105 sub 1 sub B of the CBCA, and that he was legally disqualified. So provincially, Section, are we on the right slide? I think. Yes. Section 118 sub 1 of the Ontario Business Corporations Act provides disqualification as a director by anyone found under the Substitute Decisions Act, the act that Ian has just described to us, and the Mental Health Act, to be incapable of managing property, or found to be incapable by a court in Canada or indeed in another jurisdiction. And the Ontario's Not-for-Profit Corporations Act, applicable to companies without share capital, has a similar regulatory framework that there's a disqualification of a director of a corporation if found to be incapable of managing property under the SDA and under the MHA. So And again, with that added provision, or found to be incapable by a court in a Canadian jurisdiction or elsewhere. So also of note, both the OBCA and the Not-for-Profit Corporations Act, and similar in the corresponding federal legislation, prohibit an individual from incorporating a corporation if found incapable of managing property under the SCA or the MHA, or by a court in Canada or elsewhere. And notably, there are only specific situations, again, and Ian alluded to this a few minutes ago, when a person will be found incapable of managing property under the MHA and the SCA. And this is where a person is admitted to a psychiatric hospital and a physician assesses that person as incapable of managing property, or where an authorized capacity assessor assesses an individual under the SCA and finds that person incapable of managing property. So the third scenario under the OBCA and the Ontario Not-for-Profit Corporations Act includes a director who's been found to be incapable by a court in Canada or elsewhere. And again, like previously, the corresponding section doesn't actually clarify what the finding of incapacity must be in respect of or in relation to, i.e. what decision is in question. And I guess a plain reading of the legislation arguably suggests that any finding of incapacity by a court for anything in any context could disqualify that individual. But I think this is up for grabs for interpretation in due course by our case law, by common law. So Ian, can you tell us a bit about the attorney under a power of attorney document, what the limitations are vis-a-vis the dealings with the corporate entity?
Yeah, thanks, Kim. I think it's really my starting point with continuing powers of attorney for property is, as it's described, it is a powerful tool. It is a blank check in every respect. When it's signed, it becomes effective at the time of signing, and generally speaking, the law is that an attorney can do anything but make a will. So if you've got those kinds of broad powers, you can, with great power comes great responsibility, and you can find a circumstance where the attorney is in, in some really difficult corporate decision-making contexts and problems. So first and foremost, as always, an attorney is a fiduciary and has that special relationship, of course. So the parameters of that role is that you've got to stay within that. You've got classic breach of fiduciary duty considerations, no self-dealing, stay within the scope of your authority, exercising reasonable care and skill, not make, most importantly, not self-deal or make any secret profits, and not act contrary to the interests of the grantor. Those are sort of general fiduciary duties that, for which we all know in corporate law for sure, but also in general fiduciary law. But where I think it really starts to come into play is that we've got to look a little bit further and look at some of the exposure where these attorneys have beyond that. And that's the duty to account. And that duty to account it's just so expansive, and it is a gigantic expectation of the courts that the fiduciary will be in a position to properly account, that we don't want to, I tell my clients not to underestimate A, who they're giving the job to, and B, who's getting the job, to make sure that they're well equipped to keep the right receipts and to document the accounting piece. As I say, the only real true limitation is you can't change or revoke a will, and that's really a natural expectation, because presumably your last wishes should be your last wishes, and if you become incapable, that shouldn't be changed. The difficulty you get into a little bit there is that you see testamentary-like acts being done. And the classic scenario is that you get into a situation where you use a power of attorney to maybe enter into a transaction that has tax benefit maybe on the front end for the donor, but lots of tax benefits for the donee, and you have to go to court and sort of say, look, this isn't testamentary-like. I'm not actually changing things under the will, but I kind of am because it's tax-driven. You can see how that can get complicated. Well, the same thing in a corporate scenario. I mean, you might take corporate steps that may not may look innocuous, but may end up affecting or may end up being testamentary-like in nature. The last important thing is not delegating authority, and that's a classic delineation between, are you an agent or are you a fiduciary? And an agent you can delegate to, but a fiduciary cannot delegate non-administrative tasks. The classic case is Banton and Banton, and thanks to Justice Cullity, who sent the benchmark in many respects in this area of capacity and continues to be. It's a decision of 1998, but continues to be a powerful tool to give us good guidance on what our expectations are as an attorney, the specific duties and the obligations to manage the property. And as the slide provides, we've got, staying consistent with your decision-making with personal care, encouraging participation and action and activity on the part of the alleged incapable or the incapable, depending on the determination, and to make sure you're being not just consulting, but being transparent to the extent that you can be. There is, of course, a high expectation that the financial conduct is private, but at the same time, consulting and working with family and friends is an important element of your job. You're preserving, whenever you get into court on these cases, so that once you get tested on your capacity determination, is the courts look at you and say, what is in the best interest of the incapable? And that's paramount. And I'm sure you find the same thing, Kim. Like, even judges that don't have any expertise in this area come to that point right away. What is in their best interest? Don't tell me that you went and took the incapable's portfolio and poured it all into a risky investment portfolio for the benefit of his grandchildren who one day might inherit. What was in the best interest of that person? Maybe it was actually to take his portfolio and put it into GICs. I mean, that's not intuitively something you would think about, but as a power of attorney for property, that may be the most sensible, so the safest route to take, because you're thinking about the person's best interest and you want to make sure you preserve as opposed to grow. If you're incapable and you've got enough money to live on, actually growth isn't a priority. So those kinds of determinations are important. But let's turn to a specific illustration in the context of capacity determinations for corporate matters, and that is power of attorney as a shareholder. So we know that the continuing power of attorney has broad powers. And as the slide identifies, we've got the power under power of attorney pursuant to the Substantive Decisions Act can be, of course, limited. So we need to look at the actual document. And also, these documents tend to be sometimes not all that thoughtfully done, and they tend to be either too broad or they don't include the kind of language that you'd want to have for an power of attorney in a shareholder circumstance. And certainly, a continuing power of attorney, the attorney, him or herself, has the authority to act as the personal representative of the shareholder, including legal authority over the rights of that person and so on. So you don't lose the ability to control the destiny of the shares and what's going to happen to the shares, but legal ownership of the shares, of course, is attached to the shares themselves, is governed by the attorney, and the control is directed by the attorney. There's some authority out there that's sort of helpful. The Silfer versus Bank of Montreal decision, it's a 2010 decision. There, the plaintiff argued that the undated power of attorney gave him the authority as a director was given to him by a director and a 50% shareholder. So the incapable was a director and held 50% of the corporation. That was sufficient to authorize him to commence litigation on behalf of the plaintiff corporation under the OBCA. There was some technical problems with this case. The steps taken, he didn't seek leave, and the derivative actions, of course, can only be brought with leave. The court, though, still found that the POA didn't confer the sufficient authority to commence litigation. And so we put in our POAs in the office now that express authority. Now, I'm not sure, we're not here to criticize judges and to second-guess judges, but I'm not sure that a broad power of attorney is limited in that way. But if a court is going to parse it away at the language, then it's probably very important that we put in our powers of attorney the language that specifically, and where there's a corporation involved, to specifically operate and or control shares, for the attorney can operate or control the shares and to transfer the shares. The next question might be, is obvious in a corporate standpoint, is the attorney as a director, keeping in mind that the power of attorney grants the authority to deal with the corporate shares, but may not give authority to grant the right to perform the duties of the attorney to perform the duties of a director. I think it's really, this is where as I was mentioning earlier to Kim, I mean, I think this is a real gray area. I don't know that the attorney taking on the role of director, again, without express language in the power of attorney, is going to be easily received by the courts. And certainly, while the attorney can be permitted to be appointed to be as a director in circumstances, it may not be advisable. Like, you may want to just get a third party, a neutral party in there anyway, because why would you want to get caught in the mess? Because you're going to find that you need to worry about the personal interests exclusively of the incapable, yet you're in a corporate role where you've got mixed obligations. So, as I say, I think I'm not sure that where the courts are going. There's so limited determinations, judicial determinations in these questions, but it comes back to, and we'll come back with some best practices in a minute, but make it clear. As I say, my English teacher used to say in grade 12, they'd have big, huge BS's on the paper, and I used to think that was BS, but it was B specific. So.
In your case, it probably was BS.
Yeah, it probably was a lot of BS, actually, especially in grade 12. Actually, it was grade 13 in the day. That's how old I am. So sometimes there's an incorrect assumption, though, that where there is only a sole director, the granting of the power of attorney itself was going to give you a smooth transition of the corporate governance. And, again, as I say, the directors, again, can't delegate their powers and they have a fiduciary duty to the company, but they also can't delegate those duties to third parties. And the difficulty is, you're out there, you're in a job as a sole director, and is it always going to be in the sole interest of the incapable? And those kinds of problems arise. So the solution, it seems to me, is grantors who are sole directors and sole shareholders of privately held corporations ought to consider electing some people around them, individuals around them, so that the management of the company can be seamless. Because if you're standalone, it's no different than any succession of any business. If you're a sole practitioner in a law firm, you want to have a backup plan. And if you're a sole director and sole shareholder of your privately held corporation, you want to have a backup plan. Because, as I said, the power of attorney document itself doesn't give you all of the solutions. So why don't we turn now to a little bit about the lawyer's role in terms of what you need to know in the client's capacity in the legal retainer itself. So Kim, why don't we talk about that?
Right. So you're probably asking by now, what is my role in all of this? I'm not a doctor, and I do that weekly, actually. I have no training in assessing capacity. In fact, the assessment course that's offered by the Ministry of the Attorney General isn't available to lawyers. So how do I know if my client's capable? But you need to know, because it is your obligation as a lawyer to determine the requisite legal decisional capacity of the client for the decision undertaken or the task at hand. And for example, is the client entering into a contract or transferring property or purchasing a business interest or executing a will? It's our job, it's our obligation to figure this out. Ian, you referred to Justice Cullety's decision in Banton and Banton, and one of the interesting things that he said, very insightfully, I should say, at the time, was a very high degree of professionalism may be required in dealing with these borderline cases where it's possible that the client's wishes may be in conflict with their own best interests and counsel's duty to the court. So who is responsible to assess decisional capacity depends on lots of factors, including the type of decisional capacity that we're looking at or is being assessed for the decision being made. And for example, the SCA and the HCCA require a particular individual to assess particular capacity determinations. Or for health treatment, health practitioners who propose a treatment, it's their responsibility to assess their patient to determine if they have the wherewithal to make those treatment decisions. There are a number of situations where the lawyer is responsible for assessing capacity, and we've gone through many of those today. For example, to instruct counsel, enter into a contract, to make a gift, to execute a will. A lawyer's duty is particularly significant if the client is vulnerable. And so some of the case law that I'm going to discuss next, it doesn't actually, I think, appear on the PowerPoint, but the first is the Law Society of Upper Canada and Ferrand. And that involved a disciplinary proceeding or hearing for a lawyer who represented a vulnerable person who was eventually assessed as incapable of defending himself from exploitation. So in joint submissions, the lawyer admitted to charging unreasonable fees, to breaching a court order, to misleading his client. And the panel held that the facts admitted by Mr. Ferrand raised matters which lie at the heart of a lawyer's retainer. The calling of a lawyer to protect his client, the calling is highest where the client is vulnerable, and the lawyer failed in this calling. And the lawyer received a 14-month suspension. Apparently there were mitigating factors, and otherwise the suspension may have been longer. And another one of these decisions is the Kozik estate, and that's a recent case out of Alberta, and it deals with undue influence. So there's an older adult, Ted, who met Marion at a gun show. Ted sold a farm that had been in the family for more than a century and bought a new house and invited Marion to come live with him. Ted was head over heels and proposed marriage, but before they were married or before this plan panned out, Ted had to move into assisted care. He made a new will and a power of attorney in favor of Marion. She ran through his money very quickly. She had a gambling issue. She went through all of his life savings. She never visited him. And the court eventually held that Ted's last will was invalid due to it being as a result of undue influence. And the court commented, though, importantly as follows, and I'm going to read this out because I think it's important because we put this very high standard for ourselves as professionals to determine this issue, but it's not easy in every circumstance. Sometimes it's very complex. So the court said, on the difficulties facing lawyers where there may be a hidden narrative of undue influence, unless there were obvious signs that something was amiss, as there was not in this case, the lawyer is not in a position to go beyond his or her capacity examination to test the information the client brings. Now we know from our red flags and our criteria that we interview our clients with that we can do a lot to draw this information out, but it's limited. So the lawyer doesn't know how it is or why it is that the client has adopted an understanding that produces the instructions. The lawyer doesn't know and can't know what influences have been working on the client. Those influences may still be operative or hard at work while the meeting is in progress. And a third party who has controlled and manipulated that client can continue to manipulate that client even though they're not in the room and not physically present. And the last case I want to mention is Wallman and Wallman. And in that estate, the deceased Murray married his second wife Estelle and made several property transfers and new wills that benefited her significantly. The two sons were disinherited. He had Parkinson's disease and Lewy body dementia. Went to a lawyer. The first lawyer said, no, not doing it. I want you to do a capacity assessment. So instead, he and Estelle went to another lawyer who did the job. And the court held that Murray lacked testamentary capacity and was unduly influenced, and that the drafting solicitor did many things right, including meeting with Murray alone, keeping notes, asking questions about Murray's assets, but held in the circumstances that the lawyer didn't go far enough, that the lawyer was obligated to address the substantial wealth transfers to Estelle, the disinheritance of the sons, his health issues, and had a duty to investigate the undue influence. And so all I will say is that well-intentioned lawyers can get into trouble advertently or inadvertently when capacity-related issues are at play in a retainer. So If the lawyer is confident that the client meets the applicable legal standard for requisite capacity, then you know what? Clearly set it out in your notes. Be thorough, carefully record everything, preserve the notes. A lot of these allegations or litigation comes many, many, many years after the legal service has been provided. So take extra time, ask probing questions, get the client the documents or the information that the client needs to be able to have an opportunity to answer the questions carefully. Provide them with as much information as is necessary for them to be able to provide you with instructions. Don't edit the responses of the client. You should record them as they're given. And I find a lot of lawyers, when they interview clients, they will try to give the answers for the client. So you have, can you tell me about your kids? And there's a struggle. Well, I thought you had 3 children. You can't give the answers. The point is you're supposed to be probing. And so also be careful of that person that comes to the meeting or facilitates the meeting or organizes the meeting that seems overly involved in your client's affairs. Ask why. Try to get to the bottom of why that person is so invested and what that person may have to gain as a result of all the time being spent assisting. The rules of professional conduct provide us with, I guess, a lot of consideration with respect to dealing with clients where diminished capacity is a factor, but limited, right? Mm-hmm. So I don't want to go into too much detail about these provisions, but we obviously have a duty of loyalty, which also extends to a duty of confidentiality and candor and commitment. We have the duty to keep information confidential, and so it is incumbent upon a lawyer to keep, as far as reasonably possible, a normal solicitor-client relationship, and to investigate the capacity of clients and potential clients, and to decline to act where, in fact, you believe that your client doesn't have the capacity to instruct you. And also the rules do contemplate a scenario where subsequent to the retainer, a client is no longer able to give capable instructions, at which point the lawyer, can do a number of things, including seek alternate representation or involve the public guardian and trustee. But in that regard, as Ian said earlier, capacity can fluctuate. It's fluid. Decisions can change over time, and you just have to be attuned to it. The commentary in respect of Rule 3.3 provides the duty of confidentiality is owed to every client. And so just to keep this in mind when you have the overly helpful family members who are also trying to assist, and make sure that you get express instructions from the client if you're being asked to communicate or give information to a family member, and know that the essential rights of the client can't be compromised just because of age or the well-meaning intentions of family members. So can you withdraw from representation? Yes, you can, but only if you have a good reason to, and that extends to every retainer that you have. If a lawyer has ascertained that the client is capable of instructing, then of course you're free to continue to act. That doesn't mean that you can't end the retainer. And sometimes if you determine that you have to end the retainer, maybe you have to be seeking a litigation guardian if it's for reasons of incapacity. Rule 5.1 also requires a lawyer to represent the client resolutely, honorably, within the limits of the law, while treating any tribunal or court with candor, fairness, and courtesy and respect. Keeping in mind, of course, that we are officers of the court. And so what about capacity assessments? Ian, tell us a bit about those.
Yeah, we've touched on it. Let's just drill down a little bit more on that point. first of all, a capacity assessment is a non-lawyer, I see it as a non-lawyer tool, but of course, as a lawyer, we are assessing capacity, and we've sort of talked about how we as lawyers need to assess capacity and how we react to different circumstances and what rights and obligations. But capacity assessments themselves typically take the form, medical capacity assessments, medical-based capacity assessments, typically take the form of a capacity assessment done by a trained capacity assessor. And you mentioned under the that we can't, as lawyers, take the ministry test even. They can't work with the ministry and become qualified as a capacity assessor. But the Substitute Decisions Act expressly refers to it, and there's a special list, and you can be qualified by the Government of Ontario as a capacity assessor, and therefore be able to give written capacity assessments and make determinations of findings of incapacity or capacity, depending on the circumstances. I often, in my practice, use geriatric psychiatrists. There's sort of a handful of them in the province that will do them, and they can be a really important tool. But that in and of itself can be a much more expensive process, but you can bring in for example, you can retain a doctor to come, a geriatric doctor to come see the client, or the client to go see them, and they can give you it as essentially an expert type report, but it's a capacity assessment. It's no different than other types of litigation you'd see. So these are the capacity assessors themselves, whether they're the qualified capacity assessors under the Substitute Decisions Act or a capacity assessor who's got medical training, are resources in the context of building your case, of determining whether or not you're comfortable that the individual has capacity. Now, the key really is to what? And when you say capacity, I mean, I've got capacity probably to run across the street, but I don't have capacity to run a marathon. That's a bit of a vague terminology. Those days are gone. And so,
but we could train you.
Yeah, I'm sure you could. So I think I'm untrainable in that regard. But more importantly, I think that it's that determination of what is a capacity comes down to what is it the nature of the capacity that you want to be determined. And we've talked about maybe it's just to instruct counsel, maybe it's just to do a power of attorney for personal care. And that's where we need to be very careful with the health professionals, that you give the specific determinations as to what you want them to do, and be specific as to the nature of the capacity assessment that needs to be done.
So is it your practice, Ian, to do a comprehensive letter setting out the legal tests for your assessor?
Yeah, I go back and forth a little bit. Again, it's a bit of it depends, but I have sort of a standard letter, yes, that I will set out that what I say are the legal considerations they should have. And for a Substitute Decisions Act capacity assessment, it's a little easier because you can point them to the sections. Yeah. A good capacity assessor knows all this, so sometimes I get a little shortcut with them, and just they know what, so I don't have to set it out. But how about yourself?
I usually do, yeah. Only because I was burned early in life.
Yeah. Well, it's good. It's a good practice for sure.
Yeah. So briefly, because we're getting to question time, I'm going to go through ILA, a retainer where you have undue influence and capacity issues at play. ILA is hard enough. It becomes even more difficult. These limited scope retainers are inherently difficult, and especially in circumstances where you're meeting the client for the first time, you know little about the client, the background information, the whole transaction, and then combined with the fact that the client may be vulnerable. So the gold standard is set out in a series of cases, Inch Naraya and Sheikh Ali bin Omar, Goodman and Geffen, Tulik and Ostapowicz are some authority for you to look at. Inch Naraya is a pretty good one in that decision it says that a lawyer must not only explain the nature and effect of the contract or the guarantee or the transaction, whatever the issue is, but also must have a broader understanding of the client's assets and the risk of the whole transaction and alternatives for accomplishing the transaction without risk. So ILA is the gold standard. It's not required in every scenario though. So we know that the Supreme Court of Canada observed that it is the gold standard, and that it's the one, thing that you can add to the file that truly assists in establishing that the client understood the transaction and it was entered into freely and voluntarily. It is probably the best evidence to prove free will. So the Law Society of British Columbia also provided to lawyers practicing in the area some further guidance. And they said you have to go much further in explaining the legal aspect of the matter and assessing whether the client appears to understand. You have to consider that the client's capacity, whether the client has been subjected to undue influence, whether the client has any communication issues, language barriers, physical impairments, and understand that the client really has to have more than a peripheral understanding of the documents. And sometimes you might need to engage the services of an interpreter. So with that said, Ian, tell us some of the red flags and best practices.
Yeah, that's great, and it's a good sort of wind up, and maybe we could share this section because we've talked about so many of the concepts. What are some of the practical steps that we want to take? Here are some ideas, and we've got there without reading them out loud. But I mean, I think the key is looking for the red flags, and the red flags often come to you quite naturally. And it's because you were trained to identify maybe abnormal behavior or irrational behavior is being described here. But the kinds of tests, and I have a sort of standard questionnaire that I use when I come into this point in the meeting. If I've got concerns and I'm starting to see behavior or instructions that are demonstrating to me that I've got to look beyond this to determine deeper awareness and understanding of capacity itself, and looking at unresponsiveness, looking at decision, indecisive. Well, I mean, you don't want to overplay indecisive because some people just are indecisive, and they want time to think about it. But at the same time, if you're seeing illustrations of that can be an easy, obviously, a determination. Looking at your family circumstances and what's going on around you. Who brought you to the meeting, those kind of classics, who's in the room. To the extent that there's the rule that you don't want to have anyone in the room that's tied to the gifting, that's important, but it's sometimes not that practical. Sometimes the individuals are in the room and then you start to realize that, that it is getting more sensitive in terms of the determinations of capacity, or that there may be undue influence, and so you just have them leave the room and you spend the necessary time. I think it comes to gold standards and some of that, and I think people get a little more excited about it than they should, because ultimately there's a way to manage an intermeddling familial relationship with dignity, and it comes back to some of the rules of conduct. But sometimes you have to be firm, and sometimes you have to ask tough questions, and things like, do you feel threatened? Do you worry that your son will put you into a nursing home if you don't do this, and not present with the son in the room for those kinds of tough questions. But there's a whole series of red flags. If you sit, as it describes in the slide, what kind of gifting has gone on? Are there obvious medical health changes? Those are things that we want to consider very seriously, and really. A red flag for me is how many lawyers have been involved. Is there some sort of logical inconsistency as to what's going to go on here? Why are we giving all of the pref shares to the spouse? That kind of makes sense. That's an easy, logical, consistent step for someone to put in their will if they're going to set up a spousal trust and they want the surviving spouse to hold this, to enjoy this pref shares. That's standard sort of planning tool, but when you get in a situation where they're going to give all of the common shares to a charity, for example. Well, we better make sure we look into that and what's going to be the impact of that and how would a charity react to that and those sorts of things that might be an inconsistent and maybe an illogical gift, or it may make sense. I just try to look at the gifting pattern itself. As you've described here, taking good notes are just so important, and I can't emphasize that enough. When I get into a situation where there's a gray area or red flags that are flying around, I will often literally just don't. I go into the meeting. I don't take a lot of notes directly. Then I have someone with me who's taking comprehensive notes, and then right after I will dictate a memorandum as well. So I've doubled it, because it's just too hard to properly ask questions and follow the client and see where it's going if you're not looking at the whites of the eyes, and it's too hard to be having your head down and taking notes.
Yeah, I do the same thing, Ian, when I'm Section 3 counsel. I never, ever, ever go to a meeting alone. I always take another lawyer with me, and we actually debrief afterwards to see if there's something, that I didn't pick up on that they may have picked up on, and just for that, the ability to make sure you have an accurate record of the meeting. It's very important. So it's easy to see through all of this the difficulty that we face in trying to balance our competing duties, the duty owed to the client, and duty to ensure that we have represented them properly in accordance with the rules that govern us, and that we haven't taken advantage of that client. Like often where I am confronted with a situation of potential incapacity, it's like I have to check myself and say, am I really doing the right thing here? Can I really get a signed retainer from this client? Can I take money on retainer? Or the flip side of that is, do I have the right to refuse just because I have that suspicion? And so it may take some time to figure it out, but I know you have the obligation to figure that out and then act accordingly.
Yeah, and that's interesting too, because and Cullity said in Scott and Cousins that we're not there to play God, and we need to take instructions. We need to assess the situation, and when you're in a gray zone, it is very hard to know, do you stay or do you go?
Yeah.
And that determination is always very difficult.
So Ian and I both have resources. You can go to our websites, our respective websites. There's all sorts of papers and checklists and that can assist. And so we thank you for joining us today. Our next webinar series is on November 28th. It concerns the real estate lawyer's retainer. And our final one will be December 12th on the family law lawyer's retainer. So thank you very much for joining us.
Thank you.